Thank you. Please be seated. Good afternoon. Welcome to the Iowa Court of Appeals. We're set to hear 3 cases in this 1 o'clock session. We'll have a brief recess after the first 2 cases for a panel change. The first of those cases is 24-1040 State versus Rutledge. We have Melinda Nye for Mr. Rutledge, the appellant, and we have Soich for the state appellee. Ms. Nye, whenever you're ready.
May it please the court, counsel. Article 1, Section 10 of the Iowa Constitution provides that in all criminal prosecutions, the accused shall have the right to be confronted with the witnesses against him. Recently, the Iowa Supreme Court has interpreted the Iowa Constitution's guarantee of right to confrontation independently of the parallel right found in the federal Constitution. And when they were evaluating to what extent the Iowa Constitution required face-to-face confrontation between a defendant and his accuser, the court emphasized that unlike the federal Constitution, which really encompasses only a preference for face-to-face confrontation, the Iowa Constitution guarantees the accused right to face-to-face confrontation.
That you asked the Supreme Court to retain the case to talk about, I guess, broadening the application of State versus White. How much of your request is still pertinent to the case now that it's transferred to our court?
At this point, because White is the law, but I think that sort of sets a foundation. I think the Court of Appeals can absolutely rule on this and could decide that OA's statements should have been excluded and that the Iowa Constitution right to confrontation requires the exclusion of out-of-court statements when the defendant is not able to confront the witnesses face-to-face.
In front of the horse here when that error is not preserved?
I think error is preserved. It's minimally preserved at trial. Defense counsel argued that letting OA statements in was a violation of the confrontation rights. And the Iowa Supreme Court's held that when defense counsel or when a claimant when there's parallel provisions of federal and state constitutions and they don't identify which constitution they're talking about, but just identify the provision, that preserves both claims, both a federal claim and a state claim.
Sometimes true in a general sense, but are you familiar with our Hernandez case from this year? It was published in en banc.
Sorry, refresh my memory. Yeah.
Okay.
Sorry.
Exact argument, and our court rejected it 9-0 on the error preservation question. That mention of the word confrontation only preserves a federal claim when the federal cases are cited.
Yeah, I think we've got, it's published though? Yes.
West Reporter 3rd and everything.
Well, I still stand by that, that we have Iowa Supreme Court precedent that seems to contradict that, and Iowa Supreme Court precedent saying that both are preserved when you just make a bare claim like this.
Medina reject that at the Iowa Supreme Court, where it said that if you have a mention of confrontation and you just cite the statute, you're just talking about the federal claim too.
I think that maybe then you want to get into the specific arguments that are made, like that would be exactly how it was argued. And in this case, you'll recall that it was a little bit confused. That there were a lot of objections. It took a long time. I think the state was not recognizing a distinction between confrontation and hearsay, and if it falls under hearsay exception, that satisfies confrontation. And so it was. I think the way this sort of played out shows that the state everybody was a little confused, and the judge was a sort of spoon feeding the argument a little bit, but I still think in that context, and we know White wasn't decided at the time that this trial was happening, but yet that's the law of the land. That's the interpretation of the Iowa Constitution at this point. So I don't know how you would even apply if you say that a claim is preserved, but how you apply the wrong law to an Iowa claim is just don't know if that makes any sense.
Your reference to the wrong law. Do you have an example of where we look at like kind of the overlapping between that Coy-Craig line of cases that was more at issue in White and then the Crawford-Davis kind of issues about testimonial evidence? It seems like they're both about the confrontation clause, but kind of parallel lines, if not apples and oranges, kind of oranges and lemons. It just seems like a different comparison.
I think that now that the Iowa Supreme Court has thrown off it's not following lockstep with interpretation of the Iowa Constitution with the federal, I think we've got to look at the sort of hard line that face-to-face, Iowa Constitution guarantees face-to-face confrontation. And
Ask about that specifically, because I think I'd be more inclined to follow where you're going if there was an argument about face-to-face confrontation in the record, but I didn't see those words anywhere. Are they in the record with the arguments?
again, it's confrontation clause or confrontation rights are sort of the exception, or was the objection made? The record was the state was trying to make a record, first on hearsay and then looking at applying the old law, the federal standard and the old interpretation of the Iowa Constitution about testimonial, like identifying whether it's testimonial or not.
Face-to-face rule, didn't your client need to argue for it below?
Like I said, I've just got the case.
Your record to make. I'm just trying to see a way I can get to this issue, and I'm struggling, as you can probably gather.
I think that, again, it's just, if it's enough to preserve the Iowa claim, then you've got to apply current Iowa law interpreting that Constitution, so.
Shift for a couple of your minutes and give you a chance to respond to what the state put in its Appellee's brief about basically every error you claim is harmless because of the overwhelming evidence of guilt. And you address this a little bit in your reply brief. I wonder if you could take it head on.
Certainly. The state, or the court, even if you find that there's a constitutional error, you don't have to reverse if the error was harmless, and that requires the state to prove beyond a reasonable doubt that the erroneously entered evidence affected the verdict. And in this case, you first, the strongest is, like, you look at what this evidence was. This was an assailant's identification, a victim's identification of his assailant. And that victim's identification of their assailant carries such great weight with the jury that you have to look at how heavy, even though OA wasn't in court making this identification, it's still very powerful evidence. And so if you take that out of the equation, just acknowledging how strong that evidence is.
That the video of his confession was the strong evidence.
Thing about you watch that confession, you watch that interrogation, it was, roughly an hour long. The defendant spent the first 40 minutes explaining that he didn't remember what happened that day. He was having blackouts, that he's had, sounds like, some mental and physical issues with blackouts and memory lapses since his time in the military service. And then eventually when the officer finally is like, look, I don't believe you, this is pretty convenient that you don't remember what happened that day, he starts to remember and ultimately makes this confession. And I think that when that confession, that when you look at that in context, he certainly wasn't physically tortured, he was, but when you see this, you see his responses, I think there's definitely a possibility the jury would have found that the confession portion of that interview is maybe not the truth, and that the earlier portions, when he's not remembering, that he may be highly suggestible. He's heard from his mother what the accusations are.
A challenge to the admissibility of his confession, though.
And even if we accept your argument on the confession that maybe it's not the best piece of evidence, I mean, we still have lacerations that were so severe they required general anesthesia. So I guess my question is, in a case where the defendant admits to raping the child with his penis, we have those lacerations, that kind of just severe injury. If this case isn't harmless error, what is?
I think that if you, like I said, if that confession, if, is not as strong, we know it was a limited time that he was alone with the child, but we don't know what happened. If you take the child's statements out. We don't know what happened in that, 15 to 20 minutes when mom was gone.
How are these statements of a 3-4-year-old to a nurse or to the mom testimonial?
Under that analysis, it's because for testimonial that, first to the nurse, this was coordinated by law enforcement. She admitted that while she had the dual purpose of, protecting the health and safety of the child and seeing him, she was also there to gather physical evidence for the state or for the prosecution. The statements to the mother, it comes back to this idea that, this is a young child, but he knew, 3-year-olds, if I can just wrap up, know the idea of like telling on someone. So where they may not be, preparing sworn statements in preparation for a trial, they may not have that kind of understanding. They understand the idea of telling on someone or getting someone in trouble. They have that kind of understanding. All right, thank you.
Soich?
May it please the court. Good afternoon, Your Honors, Counsel. We ask you today to affirm Taylor Rutledge's conviction for first-degree sex abuse. If I could, Your Honors, I'd like to work a little backwards and start with harmless error in case I don't get a chance to address that. We absolutely know what happened in this case. I would differ a little with my colleague in characterizing the confession as not the best confession. I think as confessions go, this one was pretty unequivocal. It is true that for about the first 43 minutes, the defendant said, I don't remember anything. I was very confused. But then when he starts to confess, Your Honors, he really confesses. He says, I raped OA. I took him into his room and I raped him. Not only does he say that, he says why he raped him. I was filled with rage. Inexplicably, I don't know why I was mad at him. I was so angry with him. He remembers that once he started anally raping this little 3-year-old, he didn't feel any better. He actually felt worse. And then he stopped. So he said it didn't last very long because I was just getting more and more angry. He remembers that then he just walked downstairs, leaving the little boy to get dressed himself and come back downstairs. Then we have the mom coming in 15 to 20 minutes later, Your Honors. It's kind of like almost a locked box mystery because we have the defendant and we have the little boy in the house. She leaves her little boy. He's happy, he's healthy, he's watching cartoons, he's playing with toys, not injured in any way. She comes back 15 to 20 minutes later, and then the little boy crying, face down on the couch, defendant acting very strangely, meeting her at the outside door. He's in timeout, he's upset. I have an electric razor, he found it, it smells like feces. The little boy runs up to the mom. He hurt me, Taylor hurt me, and he said, no, I didn't hurt you, buddy. Then he says, do you want me to show you the razor? She says, yes. She grabs him, and then he says, Taylor put his pee-pee in me. Your Honors, we also have seminal fluid and blood in the diaper. I would say very quickly that I think the record's a little confusing as to the lab report because I did notice there are 2 places where the agent testifies that there's not really any DNA evidence, that they found seminal fluid, but no DNA match. But when you look at Exhibit A1, I think it is, there is an indication that some of the diaper wipes, or at least one of the diaper wipes, had blood, and that seems to indicate that it has DNA consistent with both the little boy and the defendant. But for some reason, that wasn't really testified to in the oral testimony at trial. But we don't really need that because, again, we have seminal fluid in the diaper, the blood, his unequivocal confession, and the idea that he's the only one that had the opportunity to do this, and not to mention the child's severe anal lacerations, which required surgery. So regardless of what this court ultimately finds on the legal issues, Your Honors, this error was absolutely harmless in the state's view. Turning to the issue about what this court should do with this case.
Does White have anything to do with this case?
No, Your Honor. I don't believe White has anything to do with this case because, I do think that there are those two parallel tracks of confrontation cases. We have the cases that talk about manner of testimony or face-to-face confrontation, physical presence, Coy, Craig versus Maryland, now White. And then, in a totally related but separate kind of stream of cases, we have Crawford. And we have the fact that testimonial, whether a statement is testimonial, since 2004, has been the be-all and the end-all of any admission of out-of-court statements, of any kind of hearsay analysis. It just is. It has been since Crawford overruled Ohio versus Roberts. Since 2004, we always look at, is the statement testimonial? And in this case, I agree with my colleague. There was some initial confusion, I think, in the discussion in chambers about, well, it's hearsay, but it falls under the exception, so therefore there's no confrontation clause violation. And then the court kind of said, well, look at In Re JC. Isn't that the case that we really need to deal with? And I would urge the court, I think as in regard to the first issue, In Re JC absolutely governs this case substantively. No federal constitutional problem with the evidence in this case. With regard to the second,
Or look at In Re JC, how far does the age analysis in that case go? Does the child have to be incompetent to testify?
no, I don't think so, Your Honor. I think that, it probably is the case that most of the time a very young child could be found incompetent and probably will be found incompetent. In Ray JC, we have 4, but the verbal acuity of a 2-year-old. Here we have brand new 3-year-old, just 18 days earlier, he had turned 3. And the court does make the statement in JC, the age alone might well settle the Sixth Amendment issue. That's what the court says in that case. But then they go on.
U.S. Supreme Court ends up with Ohio v. Clark, right?
Absolutely, Your Honor. And Ohio v. Clark, I think, had just come down the year before JC. And so the court says, especially now that we read Ohio v. Clark, and Ohio v. Clark has that kind of remarkable statement that says, rarely, if ever, will a child of very young years make a statement that implicates the confrontation clause. And rarely, if ever. And here we have, again, this brand new 3-year-old. Your Honors, there is no way that this little 3-year-old boy could have intended for his statements to the nurse to be some sort of substitute for formal testimony in a later prosecution. And I was trying to kind of rack my brain thinking, what would be an example of when it might be testimonial, even though it's a young child? Because in Ohio versus Clark, the court said, a 3-year-old has no comprehension. There it was the daycare workers asking a little 3-year-old about injuries, and he told them who had injured him. And they said 3-year-olds don't have comprehension of our criminal justice system. So I was thinking, as an example, the only thing I could come up with is, let's say we have a child whose parents work in the criminal justice system. Let's say the mother's a prosecutor, the father's a police chief, let's say. And let's say that that child then knows what his parents do for a living. He knows that his mom puts away the bad guys. He knows that his dad arrests the bad guys. And then something happens where that child is hauled into the police station, and the parents say, you need to tell us everything you know so that we can arrest this bad guy, so we can put this bad guy in prison just like mom and dad do to protect other kids. If we had something, and again, I know this is an extreme example, but if we had something like that, then we might say, in this particular case, maybe, just maybe, the primary purpose of that child was to help in a formal prosecution, and the parents or whoever's interviewing that child, maybe they had that primary purpose, and that might be one of the rare cases. But in this case, we don't have anything like that. We have
That our Iowa Supreme Court in White, in analyzing the state constitution confrontation clause differently, kind of opened the door to some analysis under this line of cases where it's maybe not a primary purpose test?
Your Honor, I certainly hope not. I have read White over and over again, and at least 8 times, and I may have missed some, But at least 8 times, and I've set them out in our brief, the court says trial witnesses, witnesses at trial, witnesses who confront the defendant or who look at the defendant at trial. They say over and over again, witnesses at trial. So I don't think that even the White court, and White was obviously a revolutionary case, but what the defendant argues in this case would be way more revolutionary than even I think the White court could have imagined, to essentially eviscerate all hearsay exceptions when we have a declarant who doesn't testify at trial. And I don't think that there's any way the White court meant to do that or even suggested that that might be something down the road. As this court probably knows, the state is challenging White, I think this very week, hoping that White will be revisited. But again, White was a huge change, but nothing compared to the huge change that would result if this court or the Supreme Court were to somehow find that now hearsay statements are not going to be admissible unless that person is actually in court. Would completely upend the entire system. We ask that you...
Question I posed to Ms. Nye about Hernandez and whether it governs here, and I know you have a maybe slight advantage since it was your case that you argued.
Absolutely, Your Honor. I do think Hernandez governs. I think Gomez-Medina governs. In Gomez-Medina, the court said, if I may answer, I'm sorry, I should have. In Gomez-Medina, the court said, we are a court of correction, but if we don't have any error to correct, we can't correct something. We have to have a ruling. There's no way that anybody in this case believed that they were talking about anything other than whether something was testimonial or not testimonial. And just that kind of broad confrontation clause did not do it under any of those cases. Thank you.
Reply?
I guess I'm mostly concerned with whether you have any follow-up questions for me. Otherwise, I don't have a lot to say on rebuttal. Yeah. All right, thank you.
Thank you very much to both counsel for your really excellent briefs and your helpful arguments today. We will consider State versus Rutledge submitted, and we will have a written decision as soon as we can.